Hi, good morning. Welcome to my YouTube channel Law, Life and Layouts. Today I am discussing about top changes in BNS 2023 new criminal law which is replacing IPC 1860. In this topic I am going to discuss about what are the important changes done in BS, what are the new sections are added, modifications in this section, and new punishments. This BNS is replacing by old colonial IPC. It includes the video includes case law and sample questions of AIBE. Friends, don't forget to subscribe and share this video. BNS 2023 Bharatiya Nyaya Samhita BNS 2023 commenced from July 1st, 2024. It replaced colonial time penal law, Indian Penal Code, that is IPC 1860. Important new offences and its punishments are being discussed. Indian Penal Code 1860 has been replaced in 2023 to Bharatiya Nyaya Samhita BNS 2023. It consists of 20 chapters and 358 sections, aiming to modernize Indian criminal laws to cope with the changing times. Some offences are modified, some punishments are modified or multiplied, some sections are repealed, some definitions and offences are added, introduced community service as a new punishment. Introduced community service as new punishment, and electronic records are being considered as evidence. Electronic records are being considered as evidence. And what are the objectives of BNS 2023? First one, provide further and more effective justice system addressing issues of delay in deliberating the justice system. Providing further and more effective justice systems addressing issues of delay in deliberating the justice system. Then second one, changing the complex procedure. Nowadays the justice systems are very complex, have a complex procedure. It would be removed. Then third one, low level of use technology is to be changed to advanced technology. That nowadays low level technologies are using in jurisdiction, judicial service and investigation. New low level technologies are using, but it would be changed. The advanced technologies to be used. Then fourth one, delay in investigations to be removed. Nowadays unnecessary delay was taking place in judicial system. This and investigation, this would be removed. Delay in investigation to be investigation and judicial system should be removed. Inadequate use of forensic is to be changed. Inadequate use of forensic to be changed. The forensics are not used adequately. Nowadays it used inadequately. It would be changed. For example, in BNS, the offense having punishment more than 7 years or more than 7 years, the forensic officials are to be first visiting the crime taking place spot. The crime spot should be first visited. The forensic officers before police arriving that spot. Police should be visit after forensic officials examine the spot. Then definition. What are the important definitions? Then only here explain important two definitions. One, child. The person below 18 years are called child. The person below 18 years are called child. Then victim. Victim, any person who has suffered any loss or injury caused by the reason or an act or omission of the accused person, and include the guardian or legal heir of such victim. That means victim is also include then victim's guardian and it is legal share. That is in that definition it is included his guardian, victim's guardian, or and victim's legal heir are also included as the definition of victim. Then what are the changes, top changes in BNS compared to IPC? Then in BNS 20 chapters and 358 sections, while in IPC only 20th chapters and it has contained 23 chapters and 511 sections in former IPC. Then second, in BNS 6 punishments, one more punishment is included, that is community service. It added in section 4F a new punishment that is called community services added. In IPC only 5 punishments it is stated in section 53. Then what are the added offence, important offence? One, abatement from outside India for offence committed in India is an offence. That when one person residing in outside India and abatement an offence in inside India, then it would be offence. But while in IPC, abatement from India to do offence in outside India is offence. But that section is existing. It added more that abatement from outside India to and do offence in India, it would be an offence, section 48, and that is a new section added. Then second, sexual intercourse by employing deceitful means not amounting to rape but punishment up to 10 years. Sexual intercourse by employing deceitful means not amount to rape but punishment up to 10 years. That is section 69 says. That is for false promise, offering promotion or transfer or getting married. Then sexual intercourse conducted, it would be, it is not amounted to rape, but the punishment up to 10 years. The next one, third one, punishment for mob lynching death. Punishment for mob lynching death. It is an offence for punishment for life sentence or death. Section 103, subsection 3. But the word mob lynching is not used. Five or more people grouped together and attack a person in the name of religion, caste or language, and kill him, then that is in the section that include this section as section 103 subsection 3, and the this punishment life sentence or death. But there is another section when this mob lynching make that person attack that person and severe hurt, then he would be get punishment. That is stating in another section, another section of this BNS statement. Here, when he killed the person in mob lynching, that is life sentence or death. Section 103, section 3 would be says this punishment. Then fourth one, causing death by negligence. Causing death by negligence. This section is modified. The punishment is up to 10 years. If the offender does not give assistance to get proper medical aid to the victim, or without reported police and escape from the scene, he would be punished up to 10 years. But this section is kept abeyance due to criticism from various parts. Now this section is kept freezing and kept abeyance. In IPC, causing death by negligence punishment is up to 2 years. In IPC, causing death by negligence punishment is up to 2 years. But in BNS, it would be 10 years. Then fifth one, organized crime. Organized crime, section 111. Offences like robbery, kidnapping, cyber crime, economic crime conducted in an organized manner, in a specialized manner by a syndicate group, punished minimum 5 years, extend to life with up to 5 lakh fine. When organized crime have been done by the group of people or a syndicate, offences like a robbery, they done offences like a robbery, kidnapping, cyber crime, economic crime conducted by them, they would be punished for minimum 5 years and extended up to life with up to 5 lakhs fine. Then and next one, sixth one, petty organized crime, section 112. Petty organized crime, small crime like theft, snatching, cheating, betting or gambling conducted in an organized manner by a group, imprisonment from 1 year to 7 years with fine. They would get imprisonment from 1 year to 7 years with fine. Then 7, Terrorist Act, section 113. Terrorist Acts, offense threatened against sovereignty, security, integrity, unity of nation, and act against the economical stability of nation, and make fear or terror in the minds of the people by using explosives. They got imprisonment 5 years up to life. They got imprisonment from 5 years to life. This section is introduced by replacing previous Special Act POTA. Then next, voluntary causing severe hurt. Voluntarily causing severe hurt. That is section 117 bar 3, the subsection 3 and subsection 4. It is modified by adding two other offences. First one, by voluntarily causing hurt and putting the victim in a persistent vegetative state by voluntary causing hurt and putting the victim in a persistent vegetative state. The rigorous imprisonment for minimum 10 years extended to life is given to that accused person. Then the second is by mob lynching. A group of more than 5 people voluntarily cause severe hurt to a person due to caste, creed, or religion or language. That is called mob lynching. But the mob lynching is not used there. The word mob lynching is not used there. It is an offense for punishment up to 7 years imprisonment with a fine. It enhances to 10 years. 7 years imprisonment or and fine. It adheres to 10 years. Then ninth one, criminalized acts endanger to sovereignty, unity, and integrity of India. Section 152. Criminalized act endanger the sovereignty, unity, and integrity of India. The words here the word is sedition is removed. In former IPC, it is called sedition, section 124A. But it is the word sedition is removed. The word sedition is removed. The offence is cognizable and non-bailable punishment. Imprisonment up to 7 years. Imprisonment 7 years or life imprisonment with a fine. Critics fear that the term subversive and vague is vague and could be misused. There is a case in this. The case will be discussed later. Then 14. Mischief. A new type of mischief is added. Government property or local authority property are being damaged or destroyed or make loss to property. It is an offense. Mischief. That the government property should be destroyed. Government property is destroying due to the violence. It is a mischief, and it is an offense. Intentionally destroying, altering property, diminished its value or utility. As per section 324, subsection 2, general up to 6 months imprisonment with fine. It is applicable to private property also. It extends to 5 years and fine as per subsection 5. That is mischief, the government property or local authority property, and even the private property is make destroyed in agitation, and then it would be the people who are liable will be punished. For in ordinary case, general 6 months imprisonment with fine, but it is applicable to more. It extends to 5 years and fine as per the subsection 5 of this section. In former IPC, section 425, intentionally or knowingly causing destruction or damage to public or private property, punishment up to 3 years and fine or both is already in IPC, but it would be modified it. Then last one, making or processing counterfeiting seal in the intention of committing forgery. That the government office seal, government official seal may be making or processing counterfeiting seal in the intention of committing forgery. Section 341, subsection 3 and 4 is an offense. 3 or 4. Subsection 3 says punishment for 3 years imprisonment for mere possession of duplicate seal. Only when mere possession of public seal, that it would be punished for 3 years. And subsection 4 state punish fraudulent use of duplicate seed as genuine get 7 years or more imprisonment according to the severity of the offense. The next case law, first one, KM Nanavati versus State of Maharashtra. Supreme Court observed that an accused person under general exception, there is a presumption against him. He has the burden to prove opposite. That when a person when an accused person says that he did that offense under general consider it to be general exception, then he has the burden to prove that the circumstance to be prove it that it is under general exception. He would be proved. The burden to prove it is the accused person, not prosecution. Then second one, S.G. Bambatkar versus Union of India, challenging the constitutionality of the section criminalized acts endanger the sovereignty, unity of integrity of India. That is section 152. The court said that this section has potentiality of abuse. This section has potentiality of abuse by the officials. Then third one, landmark case of law, State of UP versus Ramaswarup, SC Supreme Court 1974. The Supreme Court held that private defense should not exercise to perform revenge against any person. Private defense should not be used to perform revenge against any person. Then the sample questions of AIBE is in my there is the time is 2 lakh, so and it is not speaking here. The questions are in my blog, Guru School Blogspot. You can read from that blog. Thank you.